Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with leaving blanks in a real estate contract and in an amendment. What happens? So you have been taught from pre-license, or you should have been taught from pre-license, that you should never leave anything blank in a contract. If there is a fill in the blank, first of all, it is there for a reason. There is some validity to that paragraph or that section where the buyer and the seller must fill in the blank to negotiate what it is that they are negotiating relative to that term. That's why there is a blank there. So first and foremost, if there is a blank in a contract, make sure to fill it in. Do not just leave it blank. If there is a dollar sign that precedes the blank, then you must fill that blank in with numerals, not words. So what happens if there is a fill in the blank and it is not applicable to the negotiations? Then you do put in NA to communicate that the buyer and the seller did look at that term, that contract provision. They did consider it, and they have decided that it is not applicable to their negotiations with respect to their agreement between them with respect to this contract. If there is a dollar sign with a fill in the blank, do not leave it blank and do not put in NA. You're going to put in 0 for $0 to communicate that the buyer and the seller did negotiate through that term, and they negotiated it to $0. They did not just not see it or leave it ambiguous. Now, if you are on a counter offer form and you are filling in the blank and there is not a change in the counter offer from the original offer or the previous counter offer, then you put NC for no change. So that's all about fill in the blanks, short, sweet, and to the point. So what happens if there is a fill in the blank and it is left blank, blankety blank? Well, a couple of things could happen, and ultimately you do not want it to get to some authoritative body like a judge or an arbitrator or GREC or an ethics board. You don't want it to escalate that far, so hence this video. I hope it helps you guys out. So if there is a blank and it is left blank, there are a couple of things to consider. And I do want to thank closing attorney Shawn Horan, closing attorney and named partner of DeFoor, Ellison, and Horan PC, for helping me walk through this process. We had a great discussion about leaving a blank, fill in the blank on an original purchase and sale agreement offer, and what happens if there is a blank left on a counter offer. So wanted to bring this information to you guys and hope it helps. So first thing is the contract in and of itself, the GAR purchase and sale agreement and the RE forms contract state that if something in the contract in and of itself is unenforceable, it does not throw out the whole contract. In other words, what's the saying? Don't throw out the baby with the bathwater. So in the GAR form specifically, it is under paragraph C, wrong paragraph. It is under paragraph CH, governing law and interpretation. And the part of that applies to this conversation is it states that if any provision herein is to be unenforceable, it shall be severed from this agreement, while the remainder of the agreement shall, to the fullest extent permitted by law, continue to have full force and effect as a binding contract. So that verbiage is similar in the RE forms standard terms as well. So what does that mean? That means that if there is a fill in the blank that is not filled in, it could be determined that that part of the contract is severed out of the contract, but it does not nullify or make voidable the entire purchase and sale agreement. Again, it sort of depends what it is that's left blank and as far as enforceability, because there are certain elements of enforceability, and if it's one of those elements, then that would render the contract voidable. But if it is something else that is not one of those 8 elements that renders a contract for real property enforceable, then the contract in and of itself would still be enforceable between the parties, just that part severed out. So it's a little more complicated than I'm portraying right here. I'm just giving you a basic broker's opinion regarding what happens if you leave a blank. So if it is an original, if it is a binding contract, not an amendment, but the terms that have been negotiated by the buyer and the seller, and there is a blank, specifically, let's talk about timeframes. So I'm going to tailor this conversation to timeframes. If there is a time frame that is left blank in a negotiated binding contract, whether that be in the offer in and of itself that gets accepted, or an offer and a counter offer in and of itself that gets accepted. If there is a time frame filled in with fill in the blank with nothing filled in, then the time frame for that contingency would coincide with the entire time frame of the purchase and sale agreement. In other words, it would go through the last day of contractual closing. Now, before I go on, let me give you an example. So, for example, let's say buyer and seller are negotiating a contract, and let's just say that there is a loan exhibit, a loan. The buyer, the purchase and sale contract is contingent upon the buyer getting a loan, and so there's a financing contingency and an appraisal contingency. Well, if any of those time frames are left blank, so in the GAR purchase and sale agreement, that would be the separate loan contingency exhibit. There is a fill in the blank for a time frame for a financing contingency and a fill in the blank for a time frame for a financing contingency. If those are left blank, then the buyer, the seller, is giving that contingency to that buyer through the entire term of the contract, which would be through day of closing. In other words, if a financing contingency time frame is left blank, then the buyer's earnest money is protected if they end up terminating based on that contingency up through day of closing, with all the other things that they have to do. And that, for the appraisal contingency for an FHA and VA insured loan, that is true anyway, because there is no fill in the blank for a time frame, so it does go through the last the time frame that the parties are in contract, which would be through day of closing. Same thing with the RE forms, and those time frames on the RE forms for the financing contingency and the appraisal contingency are in the actual purchase and sale contract in and of itself. So blank time frame for a financing or appraisal contingency or any other contingency would, if it's left blank, it goes through the day of closing. Now, what happens if buyer and seller are binding, they already have a binding contract. Let's use GAR for example. Let's say they have a binding contract and they have a financing contingency time frame of 21 days. Now, let's say there is an amendment to the contract. And let's say on the amendment to the contract, it states that let's say the buyer is changing their loan. So the amendment to the contract would say all parties agree buyer is changing their loan from this type to that type. See attached exhibit. And let's say they attach the exhibit for the new type of loan they are getting. But in this instance, they leave the time frame for the financing contingency blank. Well, in that instance, an amendment with a blank time frame, that part of the agreement would not be amended. Therefore, that part of the agreement goes back to the terms that were originally binding. In other words, if a buyer and a seller go under contract with a 21-day financing contingency on a conventional, on an FHA loan, and then they decide that the buyer is going to get a conventional loan. So they do an amendment and they state that they agree that the buyer is going to now get a conventional loan, and they attach the conventional loan contingency exhibit. but they leave the time frame for that financing contingency blank, then the time frame of the buyer's financing contingency still harkens back to what the parties agreed to in the binding contract, which would be the time frame of the, in my example, 21 days, whatever it was on the exhibit of the binding contract. It acts just like a counteroffer in that instance. So now let's look at the actual counteroffer, because this actually spells it out a little more exactly what it says. Basically, it says a counteroffer is a modification of an unaccepted original offer, including exhibits and any special stipulations. And then it goes on to say the relationship between the original offer and the counteroffer. The original offer is hereby incorporated by reference into this counteroffer. However, the terms of the counteroffer shall modify and control over any conflicting or inconsistent provisions contained in the original offer. In other words, if something is addressed in the counteroffer, then that changes what was in the original offer, including timeframes. If something is not addressed in a counteroffer, then it does not change those terms from the original offer. Well, an amendment in and of itself is, in essence, a counteroffer to a binding contract, whereas a counteroffer is still negotiating a non-binding contract. I'm making this more confusing than it needs to be. Basically, bottom line, fill in all your blanks. If you don't fill in your blanks, especially for time frames, then they coincide with the term of the contract. If you don't fill in the blank of a new time frame on an amendment, it harkens back to whatever the time frame was for that contingency in the binding contract. And just because one thing can be severed from the contract does not necessarily make the contract in and of itself unenforceable or voidable. Whew. I hope this contract tip helped you out. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.